A racist judge mocks a disabled teen in open court, thinking he's just another silent burden. What doesn't he know? The boy has spent years studying the law in secret, and today, he's ready to dismantle the entire system from the inside out. With nothing but case law, calm precision, and a mind sharper than any lawyer in the room, he turns a rigged courtroom into a reckoning. Justice doesn't shout, it outsmarts me. The stale hum of fluorescent lights buzzed over the courtroom. As the clerk called the case, people shifted in their seats, files shuffled, and eyes rolled with quiet impatience. For most of them, this was just another Tuesday in Circuit Court 12A. But at the plaintiff's table, Caroline Drake sat stone still, her posture deliberate, her breath controlled. She wore an old navy blazer 2 seasons out of fashion and a no-nonsense expression that held back a storm. Beside her sat her 17-year-old son, Jackson Drake, his thin frame tense, his hands folded precisely on the table, one foot tapping in the space beneath him with practiced rhythm. His left leg trembled slightly with a familiar spasm, but his face was unreadable. Jackson didn't look at anyone. His gaze remained fixed ahead, eyes sharp, analyzing every movement in the room, absorbing every detail. His right hand hovered near a notepad, but he hadn't yet written a word. His mouth was closed, jaw tight. To the untrained eye, he might have seemed lost or slow, but Caroline knew better. Behind that quiet exterior was a mind running loops around this courtroom before it even began. Judge Warren Hensley adjusted his robe as he took his seat on the bench, his gavel tapping once, just enough to remind everyone who held power in the room. Mid-60s, clean-shaven, silver hair neatly parted, and eyes that carried the kind of boredom that came from being in power too long. He scanned the docket and paused when he reached Caroline and Jackson's file. His eyebrows ticked up just slightly. "Ms. Drake," he said dryly, "you're representing yourself today?" Caroline stood. "Yes, Your Honor. And your son is here to observe?" She looked toward Jackson briefly. "He's here because he belongs here. This case directly affects his future." The judge leaned back, smirking. "Let's not pretend the boy can speak for himself." A soft, uncomfortable laugh rose from the defense table, where Davis Trent, the opposing counsel, scribbled lazily. Into his notes, he didn't bother hiding his grin. His client seated beside him, a slick real estate heir named Colin Price, whispered something under his breath, prompting another private chuckle. Caroline didn't blink. She didn't shift or flinch or raise her voice. She simply stared up at Judge Hensley with eyes that had nothing left to prove, only truths left to deliver. "You just made the biggest mistake of your life," she said, the words falling like "Gurn." Judge Hensley straightened slightly as if expecting her to elaborate. When she didn't, he cleared his throat and moved on. "The court notes that the plaintiff's son is nonverbal," he said flatly, "and will not be considered a competent witness in this matter." Caroline returned to her seat. Jackson's eyes didn't move, but his pen began to scratch something on the pad, quietly, methodically. On the other side of the room, a young court clerk, a new hire, leaned toward her supervisor. "What's his deal?" she asked in a whisper, nodding toward Jackson. The supervisor shrugged. "Just a disabled kid. This one'll be quick." Judge Hensley waved for the defense to begin opening remarks, his fingers already tapping a rhythm on his desk. Davis Trent stood, stretching slightly, flashing his 1,000-watt courtroom smile. "Your Honor, opposing counsel, members of the gallery," he began. "This is, at its core, a property matter complicated by emotion, mismanagement, and frankly, some unrealistic expectations about what this young man is capable of contributing." Jackson's pen stopped moving. Caroline's lips tightened. Her eyes darted toward the judge, who nodded along, already aligning himself with the words. Nobody in that room saw it yet, but the tide had just begun to shift. The air grew still. The silence between sentences started to hum, and behind that still focused expression, Jackson Drake was calculating the precise moment the courtroom would remember this day, not for its decision, but for what it revealed about everyone sitting in it. When Caroline reached for her water, her hand brushed her son's. It was barely a gesture, but Jackson nodded once. He had already mapped out every move to come, and Judge Hensley had no idea that the boy he just dismissed had memorized every ruling he'd made for the past 12 years. The courtroom fades, replaced by the dim kitchen of a 2-bedroom rental on the edge of a quiet Ohio town. The hum of the refrigerator was the only sound that filled the space between a mother and her son. Caroline Drake, hair pulled back in a tight bun, sat across from a much younger Jackson, then just 9, his legs dangling off the chair, back straight, eyes locked on the thick law book open in front of him. His lips moved, silently mouthing every word, occasionally pausing to scribble something in the margin with a pencil too short to sharpen again. again. His left hand trembled against the table's edge, the uncontrolled motion now part of the room's rhythm. Caroline watched without speaking. She didn't praise every page turned or interrupt with motherly encouragement. This wasn't about coddling. It was about precision. After a moment, she asked, "What's the distinction between a ruling and a holding?" Her tone wasn't warm. It was direct, focused, as if she were preparing him for a bar exam rather than bedtime. Jackson didn't answer immediately. Instead, he looked up at her, blinked twice, then signed the word clarification. Caroline nodded and rephrased. That's how it had always been. From his earliest years, the world had misunderstood Jackson. At 5, a preschool labeled him emotionally distant. By 7, a speech therapist recommended special placement. By 8, a pediatric neurologist finally gave it a name: selective mutism, combined with mild cerebral palsy. What they didn't understand, what most professionals failed to see, was that Jackson wasn't unreachable. He was measuring them, watching, absorbing. School was brutal. Teachers either spoke around him or over him. Some assumed he didn't understand. Others assumed he didn't care. Neither was true. Caroline pulled him out by 4th grade. Homeschooling wasn't easy. It was isolating, exhausting, and financially devastating. But it was the only place where Jackson's intellect wasn't dismissed by default. Their dining room table became a courtroom. Caroline transformed case studies into reading comprehension. Objections turned into vocabulary drills. During the day, they broke down real trials pulled from C-SPAN and local legal databases. At night, Jackson played them back, mimicking the rhythm of arguments, memorizing statements by just listening once. He rarely spoke, but when he did, it was methodical, deliberate. A single sentence could silence a room. They built a system together, not of pity, but of preparation. Caroline taught him the art of timing, when to listen, when to interrupt, when to let someone think. They'd won. She taught him the politics of perception, how his disability could be his shield or his sword, depending on how and when he used. She didn't just raise a son, she trained a strategist. The living room became their war room. On the far wall, Caroline had taped up index cards, case precedents, opposing attorney profiles, notes on Judge Hensley's prior rulings. Jackson's favorites were the ones where bad rulings had been overturned. He studied them like puzzles, grinning when he found the flaw the original judge had missed. He especially liked one dissenting opinion by a federal judge in Boston. Caroline caught him rewriting it longhand one night just to see how it felt in his own handwriting. There were no sleepovers, no high school dances, just hours of strategy. While other kids argued over prom dates, Jackson was decoding civil procedures and reviewing property law. When Caroline brought him this current case, their case, he studied it without emotion. "We'll need procedural leverage," he said flatly. It was the most he'd spoken in weeks. She knew then he wasn't just ready. He was already building a response. They practiced for the courtroom like actors rehearsing a Broadway show. Caroline played Judge Hensley, then switched to Davis Trent. Jackson corrected her when her phrasing deviated from typical cross-examination patterns. He could, mimic the legal tone perfectly but said nothing unnecessary. Brevity was his blade. Now, back in the courtroom, the past dissolved into the present as Jackson sat beside her again, older, sharper, his silence once again mistaken for emptiness. Caroline leaned slightly toward him, voice low, eyes ahead. "It's your move," she whispered. Jackson didn't look at her, but his pen stopped mid-stroke. His right hand reached for the case file. His foot stopped tapping. The room didn't know it yet, but a shift had begun, slow, invisible, and irreversible. The gavel hit wood again, sharp, deliberate, but no longer neutral. Judge Hensley leaned forward with the slow satisfaction of a man who had taken control of a room and intended to keep it. His voice carried with a new theatricality, drawing out syllables as if the courtroom were his private theater, and today's docket was pure performance. "Well, Ms. Drake," he said, gesturing lazily toward the plaintiff's table, "you've clearly read a few articles online. I'll give you credit for enthusiasm, but this isn't a parenting blog, and you're not a licensed attorney." His tone dripped with superiority, pausing just long enough to let the gallery absorb his jab. Caroline held her posture, chin high, jaw set. Jackson sat beside her, unmoving except for the sudden rapid movement of his pen across the page. The "I" sound of his writing was barely audible but persistent. His eyes didn't leave the documents in front of him, but his concentration had clearly narrowed into something surgical. At the defense table, Davis Trent took his cue. With a performative sigh, he rose, brushing imaginary lint from his lapel as he addressed the court. Your Honor, in light of the plaintiff's procedural missteps and the clear question of parental competency, I'd like to file an immediate motion recommending a reassessment of guardianship for the minor, Jackson Drake. Additionally, we ask for a court-appointed fiduciary to oversee the disputed property until the matter is resolved. The courtroom stirred. Caroline's eyes snapped to Trent, then to Judge Hensley, who nodded slowly, lips pursed in faux consideration. Interesting suggestion, Mr. Trent. Let's not forget the property in question has financial implications for the estate. If this boy can't legally advocate for himself, and his mother insists on playing lawyer, he let the sentence trail off. Then with a faint smile added, we may need to consider what's in the child's best interest. Jackson's pen scratched faster, his handwriting steady but swift. Caroline reached for her folder and pulled out a typed sheet, one they had reviewed just the night before. She stood. Your Honor, I'm submitting a procedural challenge on the grounds that this motion is being introduced without discovery, and with no affidavit establishing incapacity. Hensley didn't even glance at the paper. Overruled. Sit down. Caroline didn't move. I said sit down, Ms. Drake, he repeated, louder. The room fell into a tense hush. From behind the bench, the bailiff leaned toward the judge and murmured something too quietly to catch, but Hensley waved him off. Sir, the bailiff tried again, slightly louder. There's press outside. They're asking questions about the docket. Hensley scowled. Let them wait. I don't run this court for public opinion. Jackson raised his hand. It wasn't abrupt or attention-seeking. It was calm, steady, precise, like every movement he made. For a moment, no one noticed. Then Caroline turned toward him, and slowly, the gallery followed. Hensley's eyes narrowed. Mr. Drake, this isn't a classroom. Lower your hand. Jackson remained motionless. Mr. Drake, objection under Due Process Clause, Article 14, Jackson said clearly. The silence that followed was absolute. The words were measured and formal, spoken with a cadence that didn't match his age, but echoed something far older, something trained. For the first time all morning, Hensley blinked, an involuntary response to a sound he hadn't expected, authority from a source he'd written off. Davis Trent looked visibly thrown. He shifted his weight, glanced at his notes, then back at the judge. Hensley sat back slowly, watching Jackson now, assessing him not as a bystander but as something else, something unpredictable. Caroline didn't say a word. She didn't look at her son, didn't nod in approval. This moment had been earned, not encouraged. Jackson lowered his hand. His pen returned to paper. The gallery remained silent. Outside the courtroom, the voices of the press were getting louder, but inside all eyes had turned, not to the bench or the attorneys, but to the boy who had just shifted the power in the room with one sentence. Judge Hensley, jaw tight, adjusted his robe and cleared his throat. Noted, he said tersely. Then, quieter to himself, we'll see where this goes. The echo of Jackson's objection still lingered like smoke in the tense silence. Even the tapping of keyboards paused. Judge Hensley, who had spent the morning reveling in control, now sat unnervingly still, eyes narrowed as if trying to decide whether he'd just been challenged or outmaneuvered. From the side gallery, a low gasp broke the quiet, followed by the squeak of a chair as someone leaned in, no longer pretending to be uninterested. Then Jackson moved. Without asking permission, without a single cue from Caroline, he stood. His body, shaped by years of physical therapy and neurological stiffness, moved with effort but certainty. He walked toward the center aisle, not defiant, not dramatic, but direct. His steps were measured. His eyes were locked on the bench. His presence altered the rhythm of the room in real time. Hensley's mouth opened to stop him, but Jackson raised a single hand, flat, steady, authoritative. Under Rule 611 of courtroom procedure, he began, voice calm but unmistakably firm. A recognized speaker is not to be interrupted during procedural clarification, unless overruled by formal objection. The room was dead silent. Davis Trent, who had moments earlier filed a motion to question Caroline's fitness as a parent, stared slack-jawed, unsure whether to object or watch the spectacle unfold. He looked toward the judge for direction, but Hensley, for once, had nothing to say. Jackson reached the table at the front, pulled a copy of the case file from his folder, and laid it on the lectern like he'd done it 100 times before. He didn't bother with introductions. In Morrissey v. Brewer, the court ruled that due process is not a technical conception with a fixed content, unrelated to time, place, and circumstances. Due process, Your Honor, applies here, because the motion to strip my mother of guardianship without psychiatric evaluation, supporting affidavit, or legal basis violates procedural fairness under both federal and state law. The court reporter stopped typing. She stared at him openly now, as did the clerk and half the gallery. And in Goss vs. Lopez, the court reinforced that due process is required when state actions infringe on a protected liberty interest. My residence, my future, my autonomy. Those are liberty interests, Judge, even if I sit quietly. Trent tried to speak, but the words caught somewhere in his throat. His hand went to his tie. He loosened it. Beads of sweat began to form at his temple. At the far end of the gallery, Isabel Vance, a legal observer for the State Bar Review Committee, lowered her notebook to her lap. She didn't need to take notes for this part. She was watching something she hadn't seen in over a decade, a courtroom flip, led not by a seasoned attorney, but by a 17-year-old whose file had originally labeled him a silent accessory. Judge Hensley straightened in his seat. Mr. Drake, while I'm sure you've done your homework, this is highly irregular. Jackson cut in, not loudly but with precision. So was Brown vs. Board, sir. So was Miranda. Irregular doesn't mean incorrect. The room exhaled in a synchronized wave. Jackson turned toward the gallery for the first time and addressed no one and everyone. You asked if I could speak for myself, he said, letting the silence hold between each word. I've been preparing this argument since I was 11. Behind him, Caroline finally leaned back in her seat. Her hands rested in her lap. She didn't smile, she didn't gloat, but for the first time all day, the weight in her shoulders lifted. She wasn't holding the line anymore. Jackson had taken the floor, and there was no pulling him back. Judge Hensley reached for his gavel, but paused. He didn't strike it. Not yet. The courtroom, once a space governed by repetition and hierarchy, now felt like a live wire of anticipation. Jackson Drake stood behind the lectern, flipping through printed pages as if he were reviewing his opponent's next 10 moves. There was no hesitation in his movements, no wasted gestures. Every second he spoke, he owned the silence that followed. He cleared his throat, not because he needed to, but because he knew the effect. Now, addressing the defense's claim that my mother acted with undue influence in estate matters, he said, eyes locked on Davis Trent, I'd like to enter into record the affidavit signed by Franklin Price, notarized 6 months before his passing, explicitly stating his intent to transfer property to us without contest. Trent opened his folder with urgency, scanning for a document he didn't expect to exist. His mouth opened, but no words followed. He wasn't prepared for this level of counterattack. Jackson didn't wait. Furthermore, under In Re Estate of Porterfield 2011, the Ohio Supreme Court held that late-stage estate revisions do not qualify as coercion unless paired with medical documentation proving mental incapacity, which your motion lacks. He paused just long enough to let Trent feel the sting of being out-referenced by a teenager. Hensley tried to steady the ship. That precedent is circumstantial. With respect, Your Honor, that's exactly what law is. Circumstantial, logic, governed by precedent and constitutional framework. Jackson returned to his files, flipping to a new page. At this time, I'd like to request the court accept a shadow brief filed under amicus curiae on behalf of myself. The gallery shifted. That phrase, amicus curiae, was familiar to legal minds, but hearing it from a 17-year-old with selective mutism was another matter. Trent turned to the judge, desperate for a reaction. Hensley stiffened in his seat. You're asking this court to accept a brief from you? He asked, incredulous. Yes, sir, Jackson answered. While I am not of age to act as counsel, I am legally allowed to submit relevant material as an interested party, particularly when it pertains directly to due process and personal liberty. The document cites supporting statutes and precedents under constitutional protections afforded to minors in guardianship disputes. Silence followed. Tight, electric silence. Judge Hensley reached for his gavel but didn't strike it. Recess. 15 minutes. The gavel came down, sharp and clipped, a sign of lost composure. He stood quickly and disappeared into his chambers without further comment. The bailiff's eyes followed him, unsettled. No one said it aloud, but the energy had shifted completely. The courtroom was no longer under the judge's command. It belonged to the boy who had quietly rewritten the rules. In the hallway, the tension didn't dissipate. It simply relocated. Reporters swarmed near the courtroom doors, phones out, whispers loud enough to echo. Is the kid a savant? Did he just check the judge? What's his name again? Caroline stood just outside the chamber doors, watching the storm brew. She didn't bask in the moment, but her eyes flicked to the courtroom windows where Jackson sat calmly at their table, thumbing through a brief like he was reading a comic book. From the opposite hallway, Trent marched toward Hensley's private office and slipped inside before the door could fully close. The judge, robe loosened, stood near the window, jaw clenched as he stared at the reporters outside. "This is a circus," Trent snapped. "He's turning this into a damn media trial." Hensley turned slowly. "I don't care what the press says. He's a teenager with a disability. A teenager who just filed an amicus brief you didn't see coming. If this blows up, we're not just talking about a ruling, we're talking about bar scrutiny. Press conferences, public statements, your entire docket under a microscope." The judge waved him off. "I've survived worse." "Not in the age of Twitter, you haven't." Hensley's jaw tightened. "I won't be outsmarted by some crippled prodigy with a textbook and a martyr complex." Trent exhaled and shook his head. "Then you'd better come up with a plan, because right now the whole room's watching him, not you." Back in the courtroom, Jackson turned a page in silence, waiting for his next move. The game was no longer just about property or guardianship. This was a reputational war, and every move from here out would echo far beyond the courtroom walls. When the court reconvened after recess, the room was tighter, louder, and tenser. The benches were fuller than before, and cameras, though still technically barred, hovered outside the doors, their lenses trained on every person walking in or out. Judge Hensley returned to the bench, but the swagger he'd carried earlier had dulled. Still, he wasn't one to concede power quietly. Before Caroline or Jackson could speak, Hensley tapped his gavel sharply and cleared his throat. "Before we resume this morning's hearing," he announced, "I am filing an emergency judicial order to strike the amicus brief submitted earlier by the minor, citing procedural irregularities and lack of legal standing." Gasps rippled through the room. Even Davis Trent, who'd spent much of the morning visibly sweating, looked surprised by the abrupt move. Caroline leaned forward, ready to counter, but she didn't get the chance. From the second row of the gallery, a voice rang out, measured, calm, but unmistakably clear. "Your Honor, my name is Devin Cole, bar number 581941, State of Ohio. I'm a licensed attorney and a citizen observer. I am hereby offering pro bono representation for Jackson Drake under emergency motion with full standing." Every head turned. Devin was young, early 30s, with a charcoal suit and braided, hair tied neatly behind his head. He stood without hesitation, already walking toward the well. He carried no briefcase, just a folded document in hand, the form for legal appearance. Hensley's face flushed instantly. "You are not on the docket. You are not registered counsel in this case, and I will not allow this courtroom to be turned into a media circus. You're not in a position to decide that anymore," came another voice, this one from the back of the room. It was Isabel Vance, the legal observer from the state bar, now standing with her ID clearly displayed. "As of this morning," she said, her tone steady but sharp, "this courtroom is under active review for judicial conduct. Your rulings are now being documented as part of that inquiry. I suggest you proceed with caution." Hensley looked like a man who'd been publicly disrobed but refused to admit it. "Fine," he snapped, "but any disruption, any attempt to derail the court structure will be met with immediate sanction." "Noted," Devin said calmly, already taking a seat beside Jackson. The tension doubled. Jackson nodded once in acknowledgement but kept his eyes on the judge. Trent tried to regain momentum, fumbling through his notes for something that might reverse the tide, but Jackson beat him to it. "With counsel now present," Jackson said, "I'd like to formally request that Exhibit F be entered into evidence." Caroline reached into her folder and slid a USB stick across the table toward Devin, who immediately handed it to the bailiff. "This file," she said, addressing the court, "contains an off-the-record audio clip from the judge's chambers earlier today, captured while the courtroom mics were unintentionally left live. It includes specific language regarding my son." Hensley paled. "This is out of order." "No, sir," Devin responded. "What's out of order is what you said." The bailiff plugged in the file. The audio echoed through the room. Hensley's voice was unmistakable. "I won't be outsmarted by some crippled prodigy with a pity complex. If I have to bury this motion myself, I will." The silence that followed wasn't stunned. It was surgical. People didn't gasp this time. They didn't shift. They simply listened and stared. In the back of the courtroom, a young journalist from an independent legal blog typed furiously, then tapped once on her screen. A second later, a tweet appeared. "Crippled prodigy. Judge Warren Hensley caught on hot mic during active trial. Hashtags like Jackson Drake judicial bias outside. Phones began to buzz. Within 5 minutes, 3 news vans arrived. By 10 minutes, a local anchor was setting up under the courthouse steps. Inside, Hensley rose from his bench trying to salvage authority. This evidence was obtained without warrant, without court authorization. It was captured on an open channel. Devon cut in. And this court has no jurisdiction to suppress evidence relevant to its own misconduct. Trent looked visibly panicked. He turned to Hensley for instruction, but the judge gave none. Caroline, seated now beside her son and his new attorney, didn't speak. She didn't need to. The system was breaking in real time, not because they fought it with force, but because the truth had finally echoed loud enough for the world to hear. Jackson sat quietly, watching the courtroom fracture around him. He hadn't raised his voice. He hadn't stood again. He didn't have to. He'd already made his move, and the board was collapsing. The courtroom was no longer just a battleground. It was a stage for reckoning. When Jackson Drake entered that morning, flanked by Devon Cole, the room stilled as if expecting the final act of a story they hadn't realized they were part of. Jackson walked slowly but with intent, every movement economical, focused, his case file clutched under one arm. Caroline followed behind them, her expression unreadable but her pace steady, like she already knew how this day would end. Judge Warren Hensley sat stiffly at the bench, the corners of his mouth drawn tight, his robe pressed a little too neatly. He wore the calm of someone trying to outrun a storm already crashing at his heels. But the gallery had changed, now filled with legal observers, junior attorneys, and reporters with notebooks poised. The court wasn't just watching, it was witnessing. Devon stepped forward first, placing a stack of sealed documents on the evidence table. "Your Honor," he began coolly, "we are submitting supplemental material relevant to judicial ethics and conflict of interest statutes. This includes financial disclosures obtained from public records and investment disclosures tied to your personal portfolio." Hensley didn't blink, but his fingers tapped the gavel once, not to signal order, just to stay moving. Jackson's voice followed, quiet but deliberate. "Your Honor holds over $40,000 in equity shares in Branwyn Holdings, the parent company of Hale Realty, which is, incidentally, the financial backer of the defendants in this case. That company stands to gain substantially if the disputed property is removed from our family's claim." Whispers rose from the gallery like smoke. Davis Trent's head shot up, his mouth parting slightly as he looked toward Hensley. The judge's face remained motionless, but his neck flushed red. Caroline stood and handed Devon another folder, who stepped forward again. "According to Ohio Judicial Code, Rule 211, a judge shall disqualify himself in any proceeding in which the judge's impartiality might reasonably be questioned, particularly in cases involving financial entanglement. And so," Jackson continued, his tone sharpened now, "we are submitting a formal motion for full recusal and immediate judicial suspension, pending ethics board investigation." Hensley leaned forward, his voice low and even. "You're out of your depth, Mr. Drake." Jackson didn't flinch. He reached for a page from his folder, unfolded it carefully, and began to read aloud. "In Caperton v. A.T. Massey Colcoiner, the United States Supreme Court held that a judge's failure to recuse himself in light of a serious risk of actual bias violates the Due Process Clause of the 14th Amendment. Quote, bias on the USUA benches the first betrayal of justice." He folded the page, set it down, and looked directly at the judge. The courthouse steps were chaotic. Reporters lined both sides of the exit, their microphones raised like weapons of curiosity, voices overlapping in a rush to get the first soundbite. Flashbulbs popped, cameras rolled. As Jackson Drake emerged, flanked by Devon Cole and Caroline, the crowd surged forward, but paused just long enough to realize they were witnessing something far bigger than a court victory. Jackson didn't speak right away. He blinked into the sunlight, adjusting to the noise, the eyes, the sudden shift from anomaly to headline. His shoulders were back, his step steady, but there was no smugness, no triumph on his face, just quiet, composure. "Jackson, are you planning to pursue law full-time? What was going through your mind when you quoted Caperton? Do you think the judge will be disbarred?" Devon stepped in smoothly. "No official statements at this time, but if anyone's looking for proof that the system can still be held accountable, you just got it." They kept walking. Reporters shouted after them, but the questions faded beneath the hum of traffic and footsteps. Jackson said nothing, still, absorbing the moment with the same focus he'd brought to the courtroom, measured, internal, precise. At the parking lot's edge, Caroline fished out the keys to their dust-coated, rust-rimmed sedan, the same one she'd driven to every hearing, every therapy appointment, every tutoring session over the last decade. There was no black SUV waiting, no motorcade, no victory parade, just a cracked dashboard and a faint buzz from the loose rearview mirror. She unlocked the door, and as Jackson opened the passenger side, Devin called out, "Have you ever thought about law school, Jackson?" he asked, half teasing but not joking. Jackson turned, considering it for half a second. "I've thought about rewriting half their curriculum," he replied dryly, then added, "So yes." Devin laughed and held up his card. "Call me when you're ready. I'll sponsor your application." As Devin walked away, Caroline slid into the driver's seat, exhaling for what felt like the first time in days. Jackson settled in beside her, not saying much. He didn't have to. She started the car, the engine coughing before it turned over. As they pulled away from the courthouse, Caroline's voice came not aloud, but in narration, reflective, anchored, in memory. He didn't just win a case. He dismantled the bias that built it, and he did it without shouting, without power, without privilege, just precision and truth. The screen faded to black. Then slowly it opened in a quiet living room. Months later, morning sunlight filtered in through half-closed blinds. Jackson sat on a worn couch, a mug of coffee on the table beside him, a notepad filled with legal commentary on his lap. He wasn't dressed like a hero, just sweats, a hoodie, socks curled slightly at the toes, but his eyes were locked on the screen. C-SPAN. A congressional hearing was in progress. And in light of Drake versus Price, we believe it's time to re-examine the appointment protocols for guardianship over neurodivergent minors. One representative was saying, "It is no longer acceptable to ignore the voices of those with non-traditional communication methods. This case should be our blueprint." The camera cut to the hearing chair, the transcript scrolling. Below it, a banner headline flashed, "The Kid Who Changed the Court." Jackson didn't smile fully, just a small flicker at the corner of his mouth, like he knew there was more to come, more to do. He leaned forward, pressing pause on the broadcast, and underlined a note in the margin of his paper, "Challenge structure, not just outcomes." From the hallway, Caroline called out, "You ready for the meeting?" He stood, folded the notepad, and grabbed the folder beside him. "Yes," he said, simply, and the door closed behind him. The montage opened with a formal press conference. Judge Warren Hensley, flanked by grim-faced aides, reading from a folded statement. His voice was subdued, lips tight, hands gripping the podium. The banner behind him read, "Ohio Judicial Ethics Committee, Press Briefing. I am tendering my resignation, effective immediately," he said. "In light of recent findings, I believe it is in the best interest of the judiciary to step aside." Cameras flashed. Reporters leaned in, but there was no applause, only the sound of consequence settling in. Cut to a modest stage with a crimson curtain and a large TEDx logo glowing behind Caroline Drake. She stood alone, wearing simple black, a single mic clipped to her lapel. A photo of a younger Jackson flashed on the screen behind her, standing in that courtroom, eyes fierce and posture stiff. "I didn't raise him to fight," she told the packed auditorium. "I raised him to know when silence is power, and when it isn't." The crowd listened in stillness. Next, a sleek urban office in downtown Cleveland. Devin Cole shook hands with a line of high school students, each holding a folder labeled Future Advocates Initiative, a plaque on the wall, to be founded in honor of Jackson Drake. The camera paused on Devin watching them, hopeful, focused, before cutting away. Then, a large lecture hall filled with graduates in black gowns, tassels swaying, families cheering faintly in the distance. At the podium stood Jackson Drake, now in his early 20s. Taller, more confident, voice stronger, but still with that sharp, deliberate cadence. He looked across the crowd and said, "Don't wait for them to see you. Learn to see yourself first."